questions? Anything in your mind? No? Okay. Let's start off by reviewing from last class the 3 tiers or levels of scrutiny. Scrutiny under the Equal Protection Clause of the 14th Amendment. And I want to explain this a little bit differently than I did last night to help maybe round it out more. Very often the government has to classify people, right? Right? If you are a 13-year-old, you can't form a contract. You cannot get married on your own, right? You can't get a driver's license. You can't do a wide range of things. Now, why does the government treat 13-year-olds one way and 18-year-olds another way? It's based on stereotypes, right? The idea is generally a 13-year-old will be less responsible than an 18-year-old. Now, is that always true? Of course not, right? There are some 18-year-olds that are very immature and are very irresponsible. And there are going to be some 13-year-olds who are extremely mature and responsible, holding down jobs and the like. But often governments to act on stereotypes. And these stereotypes can be crude and not precise. But when the government is classifying people based on the age, the courts are not very skeptical. Why? Because generally, there are good reasons to treat people differently based on their age. Everyone grows up. You're not the same age forever. This is not some sort of permanent, maybe a prejudice. It's based on a recognition that sometimes sometimes younger kids aren't as mature as older people. We call these sorts of classifications non-suspect. And you've actually dealt with a non-suspect classification in the case of Williamson v. Lee Optical, right? The statute treated ophthalmologists one way, right, eye doctors, and the statute treated opticians, people made the lenses, a different way. Right, if you were an optician, you couldn't make glasses from the lensometer, and if you're an ophthalmologist, you could make glasses. Now, why they have this law? Well, maybe the eye doctors can perform an exam and might detect some latent ailments, some diseases. But again, that was a non-suspect classification, right? Whether you're an optician or an ophthalmologist is not suspect. As a result, you apply what's effectively a rational basis scrutiny. What does that mean? The government reviews the statute with deference. So long as a law is pursuing a legitimate end, maybe protecting eye health or protecting road safety, those are all legitimate ends, you only need to have a reasonable or rational fit between the means and the ends, right? You don't have to have a precise one. These are overt uses of age, right? It's expressed on the statute. But it's good enough for government work. Effectively what this means, and I'll break it down very simply, is you can rely on stereotypes. You don't need precision. You don't need specific proof that an optician is unqualified to make glasses. You can base on a general notion that ophthalmologists are better to do because they're doctors. Is it always true? Probably not. You can base it on a stereotype. Is it always going to be true that an 18-year-old is more mature than a 13-year-old? Of course not. There are plenty of immature college students and, dare I say, law students. And there are some very mature high school students. But you only get away with that sort of stereotypical approach when you're dealing with a non-suspect classification. But think of the cases we have today, right, involving gender discrimination. You have Frontiero. What was the law in Frontiero? If you were the wife of a service member, you were given some benefits automatically. However, if you were the husband of a service member, you had to jump through some more hoops to get those benefits. Why did that law exist? Justice Ginsburg argued in the case. She wasn't justice yet, but Ruth Bader Ginsburg argued in the case. The law is based on a stereotype, right? The notion that generally, if you are a male service member and your wife was living with you, then she was a dependent and she wasn't working on her own. Whereas if it was a female service member, the presumption was that the husband did have a second job, and you had to prove it. What about the second case, Craig v. Bourne? Women could buy this sort of light beer at the age of 18, whereas men had to wait to the age of 21. Why was this law enacted? There was a stereotype that women were more mature, that they could be trusted to drink at an earlier age, that they were less likely to get involved in a drunk driving offense, right? Are those stereotypes true? Maybe yes, maybe no. But the court says we can't base government policy on stereotypes about the role of women in our society. And then think of the last case, right? The city of Cleburne wanted to deny a building permit to a group home for mentally handicapped individuals. Why did they deny it? Well, based on some sort of stereotype that people with mental disabilities might be dangerous, might be harmful to communities, might be harmful to children, right? And was the court saying, no, you can't base government policy on that sort of stereotype, because they say it's an improper stereotype. You can't generalize people. What you get at here is once you go beyond a non-suspect classification, the government can no longer rely on gross stereotypes. They have to demonstrate with precision, with some sort of specificity, why they have the law they have. But then that brings us then to the VMI case from Virginia, right? The school had been male only for generations. And Justice Scalia seems convinced that they have a very good reason why they need to have separate education, which was to have this adversative, right, this sort of Spartan spirit approach to learning. Something like boot camp you went through in the Marines, right? And it won't work if you have privacy, which you would need to have if you have people of the opposite sex in the same program. And the court says, no, but that's still not enough. It's still denying equal educational opportunities. So the entire intermediate scrutiny, the sort of middle tier scrutiny, is fuzzy, right? I don't want you to think through these rigid walls where if it's a non-suspect classification, it's rational basis, and if it's this, it's another tier. The boundaries between the tiers of scrutiny are very fluid, right? Right? Did Justice Ginsburg in the Virginia case apply the same sort of intermediate scrutiny that was applied in Frontier and Craig? Not Frontier. That was applied in Craig v. Bourne. Scalia doesn't think so, right? Did the City of Cleburne case apply the sort of rational basis review that we saw in Lee Optical? Justice Marshall in dissent thinks surely not. As a result, what you'll soon learn and become frustrated by is that these tiers of scrutiny are not very rigid, especially when Justice Kennedy's at the helm. He does not like, oh, thank God. He did not like, oh, that feels good. He did not like tiers of scrutiny, but he thinks no longer really matters. But for a long time, it would drive my students nuts because I'm like, I don't know what Kennedy will do. But he did not care for standards of review, and he very rarely would label strict scrutiny, intermediate. He just wouldn't do it. He did not like those labels. And then we have the big one, race, right? Strict scrutiny. The idea that when the government classifies people based on race, it's really bad. Right? It brings to mind Loving versus Virginia, where you have a ban on interracial marriage, right? Something that is really, really evil. Generally, when the government classifies based on race, it's impermissible, right? They can't do it. Exception, however, there's an exception, however, which were the affirmative action cases, that where race was being used to promote some sort of educational benefits that flow from diversity, at that juncture, the use of race was permissible. What am I getting at here, right? Do not think for a minute that these three tiers are like, tiers of a cake, where there's the first tier, the second tier, where there's separated by frosting, right? No, these are fluid, right? This is like a gelatin of some sort, where everything sort of moves around. and the standards are not consistently applied year to year, generation to generation. Especially now, I think we're in a state of flux. I don't know how the court will approach equal protection now that Justice Kennedy's gone. I think, Chief Justice Roberts finds a way to break my heart every year, except on race issues. In those cases, he's very dogmatic. He knows what he's doing. And I think there are now 5 votes to rein in the affirmative action jurisprudence. I don't think we'll have a debate on that one. I also am skeptical that the court will treat classifications on sexual orientation and gender identity the same way that Kennedy would have. We'll have a case next year about, it's not a constitutional case, but whether federal discrimination laws protect against discrimination on the basis of sexual identity and sexual orientation. I think the government will win those cases, but I don't think they would have won if Kennedy's been here. So we'll see a shift in how the court approaches equal protection. One other note, and this also drives law students batty, the concepts of equal protection, the concept of strict scrutiny, intermediate scrutiny, right? These ideas occur in different contexts. So this is equal protection. We'll also talk about the due process clause, which we've alluded to before, right? Which is a notion that there's some rights that the court deems really important. For example, the rights in the Bill of Rights. These are very important rights. And the other rights which are deemed not important. So, for example, liberty of contract. Think of Lochner. And think of Atkins. And what we see is that the phrases rational basis scrutiny and strict scrutiny are also used in the due process context, right? So laws that violate so-called fundamental rights, laws that violate so-called fundamental rights, you've seen this phrase before, are reviewed with what's called strict scrutiny. And it operates in a very similar fashion, right, where the government must show there's a compelling state interest. They have a really good reason for doing it, right? Why are you burdening this right, this fundamental right? You have to have a really good reason. And generally, most laws that violate fundamental rights are unconstitutional. Well, for rights not fundamental, we call it non-fundamental rights. And if a law is non-fundamental, then the courts review with a more deferential, rational basis scrutiny. So you'll see the same labels, rational basis scrutiny, strict scrutiny, in both the due process and equal protection context. We will go into more depth about what makes the right fundamental. We'll do that, I think, next week. But I want you to be aware that these labels repeat. I'll give you one more preview to make your mind boggle a bit, right? Abortion rights is a separate category altogether. Now, don't you wish it was intermediate scrutiny? Wouldn't that be easy? No, no, no. It's what's called the undue burden standard, right? There's an entire new line of cases that when a law restricts abortion, the court decides whether to impose undue burden on a woman's right to obtain an abortion. I don't want you to get bogged down here, but I want you at least to be aware of it, that the phrase rational basis has one meaning in equal protection context and a separate meaning in the due process context. The phrase strict scrutiny has one meaning in the equal protection context and a second meaning in the due process context. But you're not done yet. Free speech, First Amendment, also uses the phrases strict scrutiny, rational basis, and intermediate scrutiny for free speech cases. You'll do this in another class, I promise you. But the same exact labels are used in different contexts. So you have to be very careful, right? This is a common exam error where someone's evaluating an equal protection fact pattern and they give me a test for due process. Or the case involves a due process fact pattern and you give me the test for equal protection. They're different, right? If the government is classifying people based on various groupings, race, occupation, age, etc., you need to give me the equal protection doctrine. If the government is violating certain rights, not classifying people, but actually passing a law that abridges rights, you need to give the due process analysis, right? Now, what drives you nuts is that these categories often overlap, right? Think of the optical. Was the state treating ophthalmologists different than opticians, or is the state burdening the right of contract, right? Was it in Lochner, was the court treating, in Atkins, for example, was the court treating women workers different from men workers? Or was the state burdening the liberty of contract? Let's take Lawrence v. Texas, right? Is the state discriminating against gays and lesbians? Or is the state burdening a right to engage in sexual relations? Right? Almost any case can be characterized in both ways. Think of Loving, right? Is the court discriminating on the basis, I keep saying the court. In Loving, was the state classifying people based on their race, or was the state burdening the right to get married, the fundamental right of marriage? Almost every case in which there's a violation of some right, you can also spin it as a law that classifies people in a certain fashion. So almost every case can be looked at in both lenses, which is why Justice Kennedy boggled the mind, where he would do neither. He wouldn't say there's a fundamental right, and he wouldn't say that there's a suspect classification. He would just sort of go along with things. But you need to always be on the lookout of what is the law actually doing, and what framework are you supposed to be using. Because I can spot very quickly in the exam if you're using the wrong framework. I know that quickly. That's an easy point deduction. Right? If there's a case for equal protection and you're talking about due process, you're not linking them up correctly. So make sure you use the right cases for the right framework, for the right fact patterns.
If you give us an essay that it could be either,
you have to then say that.
Do both of them? Okay.
Yeah, then say that. It's a good answer. But if you say that this is a violation of equal protection, and you start giving me due process cases, I'm not going to be happy. Yeah, the court is somewhat lazy with its terminology, and they reuse phrases over and over again in different contexts. So the same phrase can mean one thing in different contexts. It's maddening. Yeah, Audrey?
I guess we haven't done the abortion cases yet.
Not yet.
But didn't that one case, didn't it say the holding was that abortion, or it wasn't a...
You're talking about Buck v. Bell?
Yeah.
The eugenics
yes,
case?
It was a non-fundamental right. Reproduction.
All right, so Buck v. Bell was it 1927, 26? I might check my the year, but I might be off within a year or two. Right, Buck v. Bell, I think it was 20-something, right? It's 27, damn. Yeah. So Buck v. Bell was 27. That case was decided nearly 4 decades before the court began to recognize rights of privacy, as it came to be called. So it's decided during a different era. But Roe v. Wade, which I'm sure you're all familiar with, Roe v. Wade is still good law, and Roe actually cites Buck v. Bell favorably. Roe says that a woman does not have an unlimited right to her body to do what she wishes. See eugenics, right? We can sterilize you if you want, have a good reason to do so. So the Buck v. Bell line to Roe is not a straight line. In fact, Justice Thomas had this concurrence recently where he basically says that the modern day abortion movement got its roots started with eugenics, and he really made everyone else mad when he wrote that. Justice Thomas says, I don't stress, I cause stress. He really does. Yeah, sorry my phone for last night. I did stupid reporters. But I called her right back after class, so it's fine. They're very jumpy. When something happens, they need to talk to you immediately. Because if they don't, with reporters, they have to look smart to their editors and their audience, and so they need us to fill them in, and then they can look smart. They're usually good. They know what they're doing, but they're very. Phone rings, you know exactly what's going on. All right. So any question with the introduction? All right. So keep in mind as we do equal protection and the next week as we do due process that you're considering the right framework with the right cases. Even law professors get this confused. It's a very maddening thing where Justice Kennedy, he had one opinion where he said that equal protection and due process are intertwined. Like, who gives no F's left to give, just whatever, it's all together. But indeed, they overlap, I think, substantially. Tyler, you look pensive.
I'm trying to think of how to phrase the question. You've seen only one case where the government interest has prevailed even amidst strict scrutiny?
Are you talking about equal protection now?
Yes, sir.
So you're talking about the affirmative action cases?
I'm trying to reconcile the verbiage in Korematsu with affirmative action.
Oh, yeah. Oh, yeah, I guess there are two. So there's Korematsu and affirmative action cases.
So national security is an instance where even in the midst of, it's an inherently suspect class, deserving of protection of the most rigid scrutiny or whatever the verbiage was.
Yep.
I couldn't find that. We recognize it, however, we're still going to hold that the presumption of constitutionality. Is that accurate?
I don't know that Korematsu applied a presumption of constitutionality. I think they would say that the state needs a really important justification, and this one such important justification exists here. With the presumption of constitutionality, the state doesn't really need an important justification. They can just have any old interest. But I think what your question is getting at is a point that Thomas has raised, that if we take seriously the idea of strict scrutiny, that you need a compelling, not just any sort of important interest, but a compelling interest, has to be of the highest order.
Is that the only time that we've seen that national security? That's our example.
I think there are a couple instances where the court has